What does this signify for the price of XRP? Keep watching till the end to learn how to double your money. Subscribe to our channel and be sure to enable all notifications to stay up to date on the latest XRP news. Please bear in mind that the crypto market is highly volatile and crypto prices fluctuate regularly. By the time you watch this video, the price of XRP may have changed completely. Also, keep in mind that this video is just for educational purposes and should not be construed as financial advice. Before making any investing decisions, conduct thorough research on your own or contact with a financial professional. The Securities and Exchange Commission has plainly exhausted its arguments against Ripple. The agency is now pressing for a motion that would require Ripple to provide video and audio recordings of meetings attended by Garlinghouse, Larsen, and other key officials. This has been stated to be a means of gathering evidence on lawsuit-related topics. The video recordings must be of meetings in which the executives discuss matters pertinent to the case's disputes. The SEC also accused Ripple of using inadequate evidence generation methods. According to the SEC, Ripple promised to examine all recorded meetings by the custodians of such meetings, meeting name, and other criteria in a letter. The SEC basically accused Ripple of attempting to shift the burden of document production onto the SEC. The SEC goal is to demonstrate that the individual defendants Garlinghouse and Larsen, as well as other executives, were aware that XRP may be classified as a security because it was advertised as an investment contract. The SEC is especially interested in this since it is their best case against Ripple. The SEC, on the other hand, is mandated to give regulatory clarity. Hinman's deposition already established that Ripple executives attempted to understand the agency's position on XRP but were provided little clarification. The SEC claimed that Ripple as a security is faulty in and of itself, because the technology was fully created before XRP was made available for purchase. The SEC has also requested a protective injunction to prevent it from responding to Ripple's almost 30,000 petitions for admission. Attorney Jeremy Hogan, a crypto law specialist who offers his insights on YouTube, stated that the SEC request for a protective order is not unreasonable because 30,000 admissions requests is an incredible quantity. He went on to explain that it was the SEC decision to wait 7 years before initiating the complaint and to contend that all ongoing sales of XRP are securities. The dispute has effectively lasted 9 years. While the SEC awaits a decision on this subject, Ripple has discovered a vital document that could undercut the agency's overall case. The SEC published the Framework for Investment Contract Analysis of Digital Assets in April 2020. This publication takes many of its cues from Hinman's infamous 2018 speech. This demonstrates that the SEC issued market guidelines based on the speech. This undermines the SEC argument that the speech was only a personal opinion rather than policy. Ripple now has even another compelling point to make against the SEC. Ripple's legal team has argued that the SEC cannot claim DPP or deliberative process privilege because the agency has never clarified its approach on digital assets. Only personal comments from the agency's highest officers have been provided. Ripple has filed an updated response to the SEC brief on the documents that the SEC contends are privileged and so classified. Judge Sarah Netburn will shortly analyze these documents and rule on whether they are protected material or not. The updated response was submitted a week after Ripple sought the addition of 3 papers deemed by its legal staff to be extremely significant. The third document is an email chain containing conversations with a third party who was directed by the SEC to examine its digital asset using the approach outlined in Director William Hinman's June 14, 2018 address. This email conversation is thought to be extremely significant to Ripple's defense. The SEC sent this email to the third party in question, instructing them to examine a digital asset using the variables in the Hinman speech, which the court claimed was his personal opinion rather than market guidance. In this way, the agency has been contradicting itself. A memorandum from the SEC Division of Corporation Finance referring to a legal study of XRP was circulating in the SEC on June 13. The day before Hinman's speech, Attorney Jeremy Hogan stated on his Legal Briefs channel that the case can only lead to one of 3 outcomes. The first point to make is that XRP is not a security. There is no additional deliberation on this decision. The second is, XRP may be a security. If such is the case, Ripple can still win the case by claiming that the SEC failed to provide the business with a fair notice. The third and final conclusion is that XRP is a security. If XRP is a security, the SEC has no business hiding its paperwork and other analysis. The court has already ordered the SEC to turn over many of the documents that they claim are privileged to Ripple's attorney. Despite court orders, the agency has not turned over the papers. This demonstrates that the SEC is concealing something, and because this is the agency's final resort, the situation appears to be dire for the SEC. Outside of the court, Ripple has been in contact with Senator Toomey as the United States Senate prepares to review blockchain and cryptocurrency legislation. Ripple proposed implementing a legal framework that fosters crypto technology innovation and increases collaboration between the private and public finance worlds. Senator Toomey is a proponent of cryptography. She recently stated on Twitter that China's crackdown on cryptocurrency such as Bitcoin is a big opportunity for the United States. This decision by China demonstrates that the US has a structural edge over China's authoritarian rule. She went on to add that Beijing is so antagonistic to economic freedom that it cannot even tolerate its citizens partaking in what is undoubtedly the most exciting financial innovation in decades. Economic liberty promotes speedier growth and, as a result, a greater quality of life for everybody. Ripple also urged that the Senate revise its current legislative efforts, specifically the Securities Clarity Act, SCA, and the Digital Commodity Exchange Act, DC. Let's look at an XRP price prediction that will blow your head. Credible Crypto, a pseudonymous XRP analyst, expects XRP will trade between $20 and $30 during current bull cycle. This claim is predicated on a 1,000% XRP rally in 2017, which the trader believes can be duplicated in this bull cycle. The greatest gains occur in the last 10% of the bull market. Prior to the bull run, XRP was trading at 22 cents. Within a month, it had risen to $3.30. When XRP breaks its all-time high of $3.40 during this bull run, prices will enter an explosive price discovery phase. As a result, the value of XRP could rise to as high as $30. Credible Crypto stated unequivocally that he expects XRP will trade at $20 to $30 at the end of the bull cycle, whether it is 6 months or a year from now. And with that, we've reached the end of the video. What are your thoughts on the SEC dwindling position in the lawsuit? Please share your thoughts in the comments area. Please remember to give this video a thumbs up, subscribe to the channel to remain up to date on all things XRP, and switch on post notifications to be notified when new videos are released. We'll see you in the next video.